Good afternoon and welcome to AP on Play. I'm your host, Anjali Prasad, owner of Prasad Legal. I have invited attorney Kayt Dold to join us today. Kayt, welcome to the show.
Hi, thanks so much for having me.
Thank you for coming. Let's have you give a little bit of your background to the audience.
Sure, yeah. So my background is actually in social work. I've been working in the movement to end domestic and gender-based violence for over a decade. I started out as a paralegal and victim advocate working in New York City at a legal services organization that it was a little project that provided services to Orthodox Jewish survivors of domestic violence. And I worked there for about 5 years, and then I moved back to Michigan, became a social worker, and I worked at Open Arms, which is grief and trauma support. And I did a lot of legal advocacy. And while I was there, I got a little frustrated with, the system and wanting to advocate for survivors in a different way. So I went to an evening program, Wayne State Law School, and graduated about 3 years ago. And I've been working as a staff attorney at the Michigan Coalition to End Domestic and Sexual Violence since then, about 3 years now.
So it's such a mouthful. The Michigan Coalition to End Sexual and Domestic Violence.
Yeah, domestic and sexual
and sexual violence.
Sorry.
You guys need a shorter name.
I know. I get embarrassed every time I say, not because it's not needed, but because it's such a long name.
Yes. Well, tell us a bit about the coalition.
Yeah, so the coalition provides technical assistance, training, and policy advocacy for 70 member programs throughout the state. So they're all DV and SAs, domestic violence, sexual assault programs throughout the whole state. So we work closely with a lot of different programs. And then we also operate the hotline for domestic violence that is throughout the state and the sexual assault hotline. And then we have this little survivor law clinic practice. There's just 2 attorneys in there.
What is that? I was reading about that.
Yeah, so the survivor law clinic, that's where I work. We have a grant to provide legal representation to survivors of non-intimate partner sexual assault. So that means people who are assaulted by their neighbor, their coworker, their friend, sometimes an ex-partner, things like that. And we do all kinds of cases kind of centering around sexual assault survivors' safety and privacy. So we'll do PPO cases, sometimes housing. Today we're going to talk a little bit about Title IX.
Yes.
We've done a lot of parole appeal for people who've been parole granted perpetrators.
Oh, okay.
So yeah, a lot of different interesting practices, and I've met a lot of survivors who are, needing assistance, and are very inspirational for us.
Well, one of the reasons I reached out to you is because I know you're a Title IX advisor, and I thought this month is as timely as ever to do a brief overview on Title IX and talk specifically about what services you guys offer. So, with that, why don't we assume the audience doesn't have any background of Title IX? So let's start with what is Title IX.
Yeah, I think most frequently when people think about Title IX, they think about women's sports because it's a federal rule that prohibits discrimination based on sex in educational activities, and school education in general, so in school, but also in sports and, other activities that happen at a school. And so it was passed initially in the 1970s. And there's some regulations about how it should be played out in a school, how these regulations fit into that environment. And it's kind of been refined and changed a lot since, that time, and every presidential administration can change the regulations. Right now we're back on the 2020 regulations. President Biden had issued 2024 regulations, but they were challenged in court. And now the Department of Justice has dropped those, defending the regulations. There's currently a case with the Victims' Rights Center and a Jane Doe trying to intervene and take over the Department of Justice defense of them. But that's kind of all up in the air. So right now we're back at the 2020 regulations. That's been the guidance from the Department of Education to follow those. Yeah.
Okay. And I know it was passed in the 70s because I mentioned to my high school son that I was doing a Title IX session on APN Play, and I said, "Honey, do you know what Title IX is?" And he said, "Yes, Mom. Nixon passed it." So I did know it's an old federal regulation.
Yeah, that's kind of cool because it makes me wonder if he got some training at his school.
I know.
Yeah.
It was pretty cool that he knew that, and he educated me on that. And yeah, I wouldn't. I guess I didn't. I was surprised to hear that it was passed under Nixon, but good for him. I don't know if they do any Title IX training in the high schools. Do you ever go to the high schools?
We have done some training in high schools, but no, I definitely think there could be more
Yeah.
done. I think every high school, every school that receives federal funding is required to have on their website information about who's the Title IX coordinator. That's the person kind of in charge of, manning the Title IX complaints and making sure, the regulations are followed. They're required to have that on their website. A lot of schools will also have trainings that they've done for their staff. Staff is meant to be trained. I don't know if it's yearly or every couple years, but staff is supposed to be trained. And so there is information, but you have to kind of know to look for it.
Yes. And we were talking off camera about how Title IX applies not just to students, but also to staff. So it's a very wide umbrella, correct?
Yeah, so in an educational environment, so at a school, employees of the school, you could make a complaint based on a student and employee interaction, employees and employee interaction, student and student interaction. So it covers a lot of things. And it's not just sexual assault, it's sexual harassment, how we traditionally think of it. But it also includes domestic violence and dating violence, stalking, anything that kind of falls into how the federal government defines like violence, gender-based violence.
Okay, and to be clear, Title IX covers gender-based violence as opposed to, there's no racial component to it. It's all
no. Other regulations would cover that.
Yeah, that's what I was reading. I just wanted to clarify.
Yeah, there's process pretty similar, I think, for race-based. Yeah.
So Title IX covers, I guess we could call it gender-based violence or sexual harassment, correct?
Yeah, so the regulations define sexual harassment in a different way than we colloquially would talk about it.
Oh, okay.
So sexual harassment includes the assault, the domestic violence. It includes a lot of different things, including what they call quid pro quo. That's the student and employee situation where it's like if you let me touch you, I'll give you an A, or if you don't do this, I'm gonna do that. So. Quid pro quo, there's a hostile environment is covered, so that means that the behavior is so pervasive and there's it's like objectively offensive. There's a whole legal language around it, but creates an environment where you're denied access to education because of it. And then the domestic violence and sexual assault, those kinds of things.
And so let's generically walk through a Title IX case. Let's use a university as an example. Although, of course, as you said, Title IX applies to any educational institution that receives federal funding. So certainly high schools and K through 12. But let's use a university just to make it interesting. So how does the victim get to the Title IX coordinator, or is everybody? Can that person report it to anybody and then it makes its way to the Title IX office? How does it work?
Yeah, that's an interesting question. So a lot of universities will have like a website that has that information, and a lot of them have a way to make like a complaint online.
Okay.
So people do it that way. The other thing to be mindful about is that schools are required to designate folks who are mandatory reporters, people who have to tell the Title IX coordinator if they learn of any sexual harassment. And this is because once a school has actual knowledge of sexual harassment going on, there's implications for their liability. So they have to designate who is, required to report. So sometimes they'll say, like, we have confidential resources and non-confidential resources. Confidential resources are often like the counselors, things like that. And non-confidential resources are usually everyone else. So a survivor has to be mindful because let's say, I go to an advocate at the program that provides, sexual assault counseling and things. Like I can tell them what happened and they don't have any obligation to tell anyone. But I might have like a close professor that I, trust more than this advocate I just met. And I want to tell my professor about what happened. And when I do that, that might trigger a report, and I might not want to go through this Title IX process. So it's something to think about and to know about before you tell anyone, like what is everyone's obligations?
Well, I guess I'll ask this question. Are professors of universities required to report allegations to the Title IX coordinator? Because it seems to me that that's who you're going to be close with is your professor.
Yeah, I think at many universities that's the case.
Yeah. And so let's just walk through it. Let's say a survivor has an allegation and that person shares it with the professor. Then let's assume the professor has a requirement to disclose it to who? The Title IX office? Mm-hmm. And then what happens?
Then the Title IX coordinator is obligated to reach out to the complainant. That's what they call the survivor.
Okay.
So sometimes I've heard of cases where the professor is kind of reluctant to share the name. They want to,
yes,
they're doing their obligation,
yes,
but they also want to protect their student. But let's just say they disclose everything. The Title IX coordinator has to reach out and talk to the complainant about what's called supportive measures. So this is something that's really important because whether you make a complaint or not, supportive measures can help you get back to equal access to school. So let's say I'm having trouble. I've been sexually assaulted. I'm not getting my work done in a timely manner. Mm-hmm. I need extensions. That's something supportive measures can assist with. I want to change classes because the perpetrator is in my class. They might be able to help me do that. Really, it's supportive measures. You can be very creative with them.
Yes.
Sometimes we've had survivors who are like, sometimes I just need to leave class. I, start thinking about things I need to leave. I can't raise my hand. Like, I just got to go. That can be worked out with teachers, extra time on tests, things like that.
That's really cool, actually, because I didn't realize there was that step. So not every Title IX complaint is going to lead to extreme action. Sometimes there'll be supportive measures in place.
Yeah, so this is even before. So my allegation has gone to the Title IX coordinator, but I haven't made a formal complaint yet.
Okay.
So it's very complicated and it's confusing, I'm sure, for survivors too. But yeah, I don't have to ever make a formal complaint to get assistance. And this is true for respondents as well. Once the process gets going, they can also, and respondents are the alleged perpetrator.
Right.
They can also get supportive measures to help them while they're going through all this as well.
Oh, that's very fair.
Yeah, so there's supportive measures. They can be very creative. They just can't be punitive to the respondent. They can be a little bit burdensome on the respondent. Like maybe the respondent might have to like change classes or something like that. But they can't like punish them. It can't just be like you're expelled without due process. And that's the whole point of the regulations is to have some sort of due process for these allegations to be kind of played out.
Right.
But, let's say a survivor now wants to make this formal complaint.
So let's assume, in our scenario, the supportive measures aren't working or just don't adequately address the issue.
Yeah.
So then what happens?
So the survivor then can make a formal complaint and start an investigation. And one of the things we always talk to survivors about is the investigations they're brutal. They're very, you meet with an investigator, you tell your whole story. You might also have a criminal case going on. You might also have a PPO. So you really have to think this through, like, is this something that you want to add on to your plate?
Yeah.
But it depends, the only way to have a sanction at the school on a respondent for what they've done is this process. So it depends on their goals for accountability.
I think what you're saying is if there's an investigation initiated, it can be brutal on the survivor because the survivor too will be investigated.
Yeah, it's all investigated.
Yeah.
So,
Yes. Okay.
Witnesses. Sometimes, witnesses are talked to. Those might be your friends at the school. There's no way of controlling who's going to talk about what.
So this has the potential to become a very public incident.
It's meant to be, confidential.
Yes.
you
But
never
once
know.
you start interviewing witnesses, it's
Yeah, it would
like
be
you said, you
hard.
can't control who's going to say
Right.
what. Right.
So it really is thinking about it. Sometimes this is the best process for survivors because, they want their safety at school. They want to be able to continue their education. Maybe they don't want to deal with the criminal justice process.
Yeah.
Maybe,
Who does?
Yeah.
Nobody
maybe,
does.
No. Maybe accountability for them is, the school having a sanction on the respondent. And it's not, jail time. That's not what they want.
Yeah.
The other option sometimes schools usually have like an informal process too. And I think we were kind of talking about this off camera. Like you'd had a case
Yes,
before, and
I
they
think
negotiated.
I think that's where I landed. I had a case with a local university where I represented the accused or the respondent, and I didn't know too much about the Title IX process, but we ended up negotiating a kind of a resolution that included maybe changing some courses and basically a stay away order, stuff like that, like a no contact, can't talk to the person, can't post about the person, these kind of things.
Yeah.
So that's where I think we landed in the process.
And I think that can be a good option for a survivor who doesn't want to go through
Yes,
an investigation. We've had cases where the respondent issued an apology, things
I think we
had to listen to an impact statement.
Yes.
So the survivor was able to say how much they'd impacted them. They could feel heard.
Yeah. And that's where the university can really get creative.
Yeah.
Right?
And
Because
different schools have a lot of different
Yes.
things. So it can be another option. It doesn't have to go through the investigation process.
And I would think that the school too wants to resolve it in a non-extreme way.
Yeah. I think, that benefits them to get it
Yes,
done. The investigation process can take a lot of time.
Right.
So what usually happens if that's the route you go is an investigator is assigned to the case. They'll interview the complainant. They'll interview the respondent. They'll interview all the witnesses that they offer. They might interview people that just kind of come up and convert. You tell them about witnesses, but they might reach out to other people.
Mm-hmm.
And then they compile, at the university level, they usually compile this report that's called a preliminary investigation report. And every school can kind of make their own system, so it can look a little different. But generally speaking, there's this initial report of everything that they've come together in the investigation. Right. And then you have an opportunity to respond to it. So you read it over, and then you can say, like, oh, you didn't talk to this person, or you didn't ask that person that, or, this person isn't credible because of this, and I have this evidence that I can submit. So that takes a little while. You're kind of going back and forth on this report. Usually you have like a certain amount of time to respond, like 10 days. And then after that, they issue what's called a final investigation report. So that's compiling the initial report and then every response that there's been and then any additional investigation they've done.
And in the meantime, during this process, you or somebody from your office, I think, would be involved in kind of, are you representing the survivor at this point?
Yeah, so I call myself an attorney advisor usually, but an advisor can be anyone. You could use your friend, you could use whatever. The regulations have a role for an advisor for the hearing, which we're going to talk about in a second. Okay. But really the only required time you need an advisor is to do cross-examination at the hearing.
Okay.
You can't ask questions of the other party. Like, you have to have someone to ask your questions. But what our clinic does is come in at the very beginning, or whenever we're called, but typically the beginning. And so we go to all the interviews, and that helps because, often you get an opportunity to, like, refine what you've said.
Yes,
we have those opportunities. And we insert a lot of advocacy about, like, education about domestic violence or sexual assault, whatever the situation is, when we're doing responses and, how the survivors might be vulnerable to the assault, talking about the issues that credibility might bring up.
Right.
And so we get a chance to kind of advocate before we get to the hearing. And that's really valuable because even when advisors are appointed by the university, and in most cases they are, those advisors don't do that kind of work. And it's a lot to do.
Yeah,
it's a lawyer's job.
It's a lawyer's job, yes.
And it's really hard for, someone in the stress of it and the trauma of the experience, for both perpetrators and survivors to
In this
respond.
scenario, does the respondent know they're under investigation?
Yeah, so there's an obligation, and I should have said this in the beginning. Once there's a formal complaint, there's an obligation by the school to send like a notice of investigation to both parties, and they do that
Okay.
simultaneously.
Yes. And so the respondent too, I would imagine, would hire an attorney just to
Yeah.
navigate that process for the
If there's a
person.
criminal
Yeah.
case, and many times
Yeah.
it's the criminal attorney
Right.
that's helping them with this, sometimes it's not. But
Right.
yeah, I think it would benefit someone to
Yes.
hire someone because
Yes.
the implications of these cases are severe.
They're very severe. Yes. So okay. So now in this hypothetical, the investigation is happening, and
Yes, you've got
Yep.
both your reports, and then there's a hearing. So the 2020 regulations require a live hearing where both parties are cross-examined. You can choose not to be cross-examined, and a hearing officer is not supposed to read anything into that. But, I mean, generally speaking, I think it does kind of create a bias,
Yeah.
perhaps.
so is the hearing officer is the judge in the hearing, basically?
Yeah, so the hearing,
Okay.
in my experience at universities, it's usually like an outside attorney that they bring in
Oh, okay.
who
Interesting.
manages this, yeah. And so you meet with a hearing officer for a pre-hearing meeting. They kind of go over what their rules are, what the expectations are of the hearing. Usually there's some kinds of accommodations for the hearing, so people ask, can I turn my camera off when I'm not talking? A lot of them are on Zoom now, thankfully, instead of like in person
Yeah.
live, yeah. So, you can ask to turn your camera off. You can ask, sometimes they let you use your phone to talk to your advisor during the hearing where they wouldn't allow that normally.
Right.
You can be creative again, asking for accommodations. And once the hearing officer is involved, they kind of take over. The investigator's gone, and the hearing officer is making the decision about what happened. And then here you get to choose what witnesses you want to call. And what's a little different than our experience of calling a witness is that there's no like everything that's in the investigation report is already in.
Oh,
So at the
okay.
hearing, we don't have to like establish the whole timeline.
Right,
We don't
yeah.
have to tell the whole story. We don't have to do all that. So that's a little, makes it a little easier. But you have to tell them what witnesses you want to call. And the only reason you call witnesses is to challenge their what they've said or
Right.
ask them for more information about things they said. So if you offered a witness and they said favorable things about, for your case, you're not really going to call them and like challenge them or
Yeah.
anything.
So there's a hearing
Mm-hmm.
with a hearing officer, and the hearing officer then determines whether the allegations happened or not, basically.
Yeah, and I think what's also a little different and what survivors need to be aware of is that these hearings, the cross-examination questions can be more broad than they might be in a court. They have to be relevant, so every time you ask a question, it's a little clunky, but you ask a question and then the hearing officer has to rule whether it's relevant
Oh,
or
I
not.
see. Okay.
And then the person can answer.
Yeah.
So during cross-examination, that's how that works. So they can determine whether everything's relevant, but it is like,
So
more broad.
let's say there's a finding of fact that the event occurred or that the allegation occurred.
Yeah.
Then where does that leave us?
So usually what happens is you have this hearing, and then the hearing officer has like 30 days, but sometimes they take longer, to be frank, to issue their decision. And they're usually like big, better than any decisions we get from the court. I mean, they're 30 pages long, going through everything
Yeah.
that they found. And then usually what happens is they're not the ones who decide the sanctions. So
Okay.
the sanctions then go to like whoever's in charge of like student conduct, like a dean or someone. And they decide what the sanctions could be. And they could be as far as expulsion.
Or termination if the
If
person's
it's
a staff
employee,
member.
they could
Okay.
be, something like, take a class, read a book. Sometimes they're brief, like you can't take classes for a year, but then you could re-enroll if you wanted to. But this kind of sticks with you, right? So
Yes.
this is on your
This
trans.
is-
When you're going to
yes.
apply, a lot
Yes.
of schools ask you, like, do you have, have you had a Title IX complaint against you, like things like that, and they could get access to that
Yeah.
information. So that's why it's important for respondents to also seek legal advice about
Yes,
it. Yeah.
absolutely. And it seems to me, I mean, I'm a trial attorney. I like to go to court and fight. But in this kind of scenario that we just talked about, it seems to me that if you can negotiate these supportive measures, that's possibly best for the respondent and best for the survivor.
Yeah, depending on the situation.
Yeah.
Everything we do is survivor-centered, so I will say that many survivors do want to go through the process for
Yes,
that
'cause
accountability.
of course.
But
Right.
yeah, I think there are others who prefer to have like a negotiated informal resolution.
Do the Title IX, if the university receives a Title IX complaint, are they obligated to refer it to law enforcement or no?
Some universities have a policy where they do report it to law enforcement, but not everyone is. Yeah,
Okay.
Not everyone does.
So sometimes the Title IX proceedings could be in lieu of criminal proceedings.
Yeah, and there's a different standard too. So the standard in these hearings
Yes,
is either
yes.
presumption or preponderance of the evidence or clear and convincing.
Yes.
The school gets to choose. There is a presumption that the respondent did not harass. As
Okay.
There is in like
Is there in the criminal?
Yeah,
Right,
but
right.
the standard is lower. So
Yes.
I mean, you could lose any of these cases and win in a different one. It's
Yes.
all,
Yeah. Where are you seeing the Title IX litigation centralized now? Is it in the university setting? We were talking off camera about sports settings.
Yeah, I think right now you see a lot of it in the news about sports.
Yes.
But I mean, these happen everywhere. Like
Yeah.
there's no dating violence, sexual assault, it happens everywhere. So
And it's not even. I mean, now we're hearing of same gender violence, right? The sexual assault within the same gender. So it seems like, I don't know what it seems like. It seems like it's very, it seems like Title IX has a very broad, not audience, that's the wrong word, a broad
Yeah.
net.
It does, but
it
it's
has a
also
broad
limited.
net.
So the 2020 regulations require that the incident occurred like in the United States and
Okay.
during an educational activity. So it might be students, but they might be outside of class.
What
So
is it required that the incident occur on campus?
in something that's controlled by the university. So let's say we did like a field trip.
Okay, got
It's
it.
controlled
Yeah.
by the university. But like if I'm just hanging out with my friends who also go to school,
Yeah.
that's not controlled by the university.
But what about like
A dorm is
a
controlled.
dorm? I was thinking of like a rec center where people play sports on campus.
If it's controlled by
Yeah.
yeah. So it kind of is a case by case assessment.
Yes.
And that requires a Title IX coordinator to kind of look at the facts and
Yeah.
figure it out. Because sometimes things that happen outside of the school might come into the school,
Right.
with like bullying or something.
Yeah.
And so,
Bullying would be a big one.
It's a pretty I hope
It's
that
pretty
we've-
common, yes, yeah.
We've explained that it's a pretty complicated process
Yeah,
at the least.
it is a complicated process. I'm really grateful to you for coming on the show this morning. Really grateful for the work you do because this is a really important area of the law. Survivors need advocates and respondents need attorneys. So my hope today is just to educate the audience on the process and what's available to both parties under Title X. And I don't know, maybe you can come back in a few months and keep us updated on this area of the law.
Yeah, and I think one thing that viewers want to know about is that the funding for these types of services, for my job and other DVSA programs, are in jeopardy right now. You can write your state representative and ask for them to approve the $75 million to cover our VOCA gap from federal funding.
Okay.
And also, like my project is funded through a grant through the Office on Violence Against Women. And they've pulled down all their solicitations and they're not offering funding right now. So a lot of our programs in the state receive federal funding. So asking them to reopen their solicitations and
Yes.
give out grants
Yes.
would be very helpful. Yeah.
Duly noted. Thank you. And thank you, audience, for tuning in to AP on Play. We will see you next time.